Trying to erase sworn courtroom testimony with a press release is like trying to shove toothpaste back into the tube using a brick. The harder you push, the messier it gets. That became the White House strategy Saturday morning after Pam Bondi stood in federal court and said something Donald Trump's legal orbit cannot easily contain, cannot casually redefine, and cannot pretend never entered the record. Because once a sitting attorney general tells a federal judge that the president communicated which Epstein materials should remain hidden, the problem stops being public relations and starts becoming institutional survival. At first, the hearing looked forgettably procedural. Lawyers carrying binders, redacted pages stacked across tables, federal staff whispering into each other's ears while reporters refreshed court dockets looking for movement. Judge Sullivan entered the room expecting another argument over compliance timelines tied to the Epstein document inventory he ordered the Department of Justice to produce by Saturday morning. 41 names remained blacked out. Same names, same wall of secrecy, same slow-motion resistance wrapped in polished legal language. Then Sullivan asked the question that changed the temperature inside the courtroom. He wanted to know whether those redactions came from the Department of Justice's independent legal judgment. Not politics, not optics, not conversations, legal judgment. Pam Bondi paused. 14 seconds does not sound long until an entire courtroom waits inside it. 14 seconds with federal reporters staring up from laptops. 14 seconds while DOJ attorneys suddenly stopped writing notes. 14 seconds where everybody in that room understood that the next sentence mattered more than every procedural filing submitted over the past week. Then Bondi answered. She stated that the decision to withhold specific names followed guidance received from the executive office. Sullivan immediately pressed further, asking whose guidance she meant. Bondi hesitated again before saying the president communicated that certain materials would not be produced. That was the moment this stopped being a dispute over documents. Now the story became whether Donald Trump personally intervened after a federal court had already ordered production. And timing destroys almost every friendly interpretation available to the White House. According to the testimony, the communication occurred on April 19th, days after Sullivan's production order already existed. That detail matters because executive privilege arguments look very different before a court order than after one. Before the order, lawyers can frame discussions as internal deliberation. After the order, the legal danger shifts toward potential obstruction territory. That is exactly why DOJ attorneys looked panicked less than an hour later. At 10:12 a.m., Sullivan suspended proceedings and called the admission extraordinary. At 10:47, the White House released a statement claiming Bondi's testimony was imprecise. Notice what they did not deny. They did not deny communication occurred between Donald Trump and Pam Bondi regarding the Epstein files. They challenged characterization instead. In legal warfare, that distinction is enormous. When someone argues over wording instead of substance, it usually means the underlying event already happened. Then came another detail almost nobody outside Washington initially noticed. Pam Bondi hired personal counsel 4 days before this hearing. Not DOJ representation, not administration attorneys, personal counsel. People do not prepare separate legal protection because they expect smooth cooperation ahead. They do it when interests begin separating behind closed doors. That move changed the political geometry instantly because it suggested Bondi may already be thinking less about protecting Donald Trump and more about protecting herself. And that creates the nightmare scenario for any White House under pressure. The first insider who starts building distance from the administration usually understands where the fire is spreading before the public sees smoke. What made the situation even more dangerous was how quickly the containment strategy started collapsing in public. Normally, Washington scandals move through carefully managed stages. First comes denial, then delay, then controlled clarification through friendly media channels. But this timeline moved too fast for choreography. 59 minutes after Pam Bondi's testimony hit the courtroom transcript, the White House was already scrambling to reinterpret words that had been spoken under oath in front of a federal judge. That speed alone told experienced legal observers something important. They were reacting to damage, not executing a prepared rollout. And Judge Sullivan understood exactly what landed in his courtroom. Federal judges hear evasive answers every week. They hear memory lapses, privilege claims, procedural objections, selective phrasing designed to protect political interests while technically avoiding perjury exposure. But Sullivan suddenly found himself facing something different, a sitting attorney general directly connecting suppression of court-ordered material to presidential communication. That is not routine friction between branches of government. That is the kind of allegation capable of forcing the judiciary into a confrontation it usually spends enormous energy trying to avoid. Because courts do not possess armies. They do not control budgets. They rely on compliance. That is the hidden engine underneath the entire American legal system. Judges issue orders because the executive branch is expected to follow them even when compliance becomes politically painful. Remove that expectation, and the entire structure starts wobbling. A courtroom without enforceable authority becomes theater with nicer furniture. And this is where the logic trap tightened around the administration. If the White House argues Donald Trump merely offered general guidance, they still have to explain why the guidance resulted in continued defiance after a federal production order already existed. If they argue executive privilege protects those conversations, they must explain why privilege was never asserted before. Bondi answered Sullivan's question directly. If they attempt to erase Bondi's statement entirely, they create another problem. Federal transcripts are not social media posts. You cannot delete them because communications staff dislike the headlines. Look carefully at what happened next. At 11:03 a.m., DOJ Litigation Counsel filed an emergency motion asking the court to strike Bondi's statement from the record, claiming it mischaracterized deliberative process communications. Again, notice the wording. Not false, not fabricated, mischaracterized. That distinction matters because it quietly concedes the conversation itself occurred. Experienced prosecutors hear those linguistic pivots immediately. It sounds less like, "This never happened," and more like, "Please interpret what happened differently." Then the Senate entered the picture. Dick Durbin announced an emergency Judiciary Committee hearing for Monday morning. Lindsey Graham joined him. That changed the political equation instantly, because Graham is not some random cable news critic floating outside Republican power structures. Graham has defended Donald Trump repeatedly through impeachment battles, investigations, and media firestorms. For him to publicly support a bipartisan inquiry into White House communications with DOJ signaled that concern inside Republican circles may already be deeper than the public realizes. And here is where the moral contrast becomes impossible to ignore. Imagine an ordinary federal employee receiving a lawful court order, refusing compliance after private instructions from management, then admitting under oath that outside pressure influenced the decision. Nobody would call cable news panels to debate constitutional nuance. Nobody would spend 72 hours arguing semantic differences between direction and guidance. Security clearance gone, employment terminated, investigators waiting by Monday morning. But when power reaches the presidential level, accountability suddenly becomes negotiable language. That is why this story is landing so hard with the public. Not because Americans obsess over procedural filings in the Epstein investigation. Most people never read court dockets. Most people never watch federal hearings. What they understand instinctively is something simpler. There cannot be one legal gravity field for powerful people and another for everybody else. And once citizens start believing the rules bend depending on status, trust in the institution itself begins collapsing faster than any single political career. And that is exactly why the White House suddenly found itself fighting on 3 fronts at the same time. Not one. 3. The courtroom, Congress, and public credibility. Each arena operates under different rules, which means a strategy that works in one place can become catastrophic somewhere else. Political messaging may calm television audiences for a few hours. It does not neutralize sworn testimony sitting inside a federal transcript. Executive privilege may delay disclosure battles in court. It does not automatically stop congressional investigators from issuing subpoenas. And none of it changes the visual Americans already absorbed from this hearing. Pam Bondi standing before a judge, pausing for 14 seconds, then connecting presidential communication to withheld Epstein materials. That image is now permanent, and Judge Sullivan knows permanence is the real danger here. Because once a federal judge believes there may have been interference tied to compliance with a court order, procedural patience starts disappearing. Sullivan's language already shifted dramatically during the hearing. Earlier filings from the court used restrained institutional wording: review, clarification, production timeline. After Bondi's testimony, the vocabulary hardened. Suddenly, the court was discussing operative facts, written briefings, emergency review, and potential referral questions. That transition matters because judges choose words carefully when building records that higher courts may eventually examine. Now add another layer. 3 former federal prosecutors publicly stated before noon that Bondi's admission could represent one of the clearest modern examples of alleged executive interference in an active legal matter. Even conservative legal commentator Jonathan Turley acknowledged the situation could not simply be waved away procedurally. When legal analysts from opposing ideological camps begin converging on the same concern, Washington notices immediately. That is usually a sign the issue has moved beyond partisan spin and entered institutional risk territory. Then came the comparison nobody inside Trump's orbit wanted revived. Watergate. Former Watergate prosecutor Jill Wine-Banks stated that Bondi's testimony structurally resembled the dynamic surrounding John Dean in 1973. Not because the cases are identical, but because the pattern feels disturbingly familiar. An insider, presidential pressure, a legal process under strain. A key figure beginning to separate personal survival from White House protection. History does not need to repeat perfectly to trigger political panic. Sometimes it only needs to rhyme loudly enough for the public to recognize the melody. And look at the strategic behavior unfolding behind the scenes. Pam Bondi appears increasingly focused on narrowing her own exposure. The White House appears focused on reframing the event as misunderstood executive communication. Congress appears eager to expand the confrontation publicly because hearings generate visibility, pressure, and leverage. None of those goals align cleanly. That is why the situation keeps escalating instead of stabilizing. Think about the impossible position Bondi now occupies. If she walks back her statement Monday, her credibility collapses because the original testimony already exists under oath. If she doubles down, she intensifies the obstruction question surrounding Donald Trump. If she refuses to answer Congress entirely, the administration risks simultaneous conflict with both the judiciary and the legislative branch within the same 48-hour window. There is no elegant exit remaining, and meanwhile, outside the legal warfare and constitutional language, another reality sits quietly underneath all of this. The Epstein victims families have spent years waiting for transparency. Years watching powerful names sealed, delayed, buried behind procedural barriers ordinary people could never afford to fight through. That is the moral center of this story. No communication strategy can erase. Wealthy figures hire elite attorneys, negotiate timelines, invoke privilege doctrines, and debate institutional boundaries, while victims wait decade after decade for basic answers. That contrast poisons public trust faster than any headline. Because Americans can tolerate political conflict, they can tolerate scandal, they can even tolerate hypocrisy for a while. What they struggle to tolerate is the growing suspicion that power itself determines which truths become visible and which disappear behind black bars on government documents. And once citizens begin believing the justice system operates selectively, every future ruling inherits that doubt automatically. Which brings us to the part Washington fears most. Not the scandal itself, but the precedent left behind after the cameras move on. Because political damage eventually fades. Poll numbers recover, media cycles shift. But institutional precedents stay alive for decades. Lawyers cite them, judges remember them, future administrations quietly study them to learn what boundaries actually held and which ones folded under pressure. That is why Monday morning matters so much. Judge Sullivan is no longer deciding a narrow dispute over redacted Epstein records. He is now staring at a far larger question sitting underneath the filings. Can a president allegedly intervene after a federal production order and still expect the justice system to absorb it as routine executive communication? Once that question enters the record, every possible ruling becomes dangerous. If Sullivan treats Bondi's testimony as operative fact, the obstruction issue explodes, politically and legally. If he minimizes it, critics will argue the judiciary blinked when confronted by executive power at the highest level. Either path carries consequences far beyond Donald Trump, and the White House knows it. That explains the increasingly frantic attempts to slow the timeline before Monday's hearing. Reports already indicate White House counsel pushed for formal privilege assertions, while DOJ communications officials abruptly stopped press engagement surrounding the Epstein case. Again, watch behavior instead of rhetoric. Institutions reveal panic through movement patterns long before they admit concern publicly. You do not freeze communications strategy during a routine misunderstanding. You do not dispatch emergency legal coordination teams because somebody used slightly imperfect wording in court. Those are crisis management actions. Meanwhile, Congress smells vulnerability. Dick Durbin wants answers. Lindsey Graham wants distance. Federal prosecutors see potential exposure. Cable networks see ratings. And every faction inside Washington now understands the same thing. Once this conflict reaches the point where the judiciary, the executive branch, and Congress are all pressuring each other simultaneously, control becomes almost impossible to regain. That is the hidden lesson from Watergate most people forget. The collapse did not happen because of one recording or one hearing. It happened because the system stopped trusting itself internally. Allies became witnesses. Defenders became negotiators. Private loyalty started competing against legal survival. You can already feel traces of that atmosphere forming around this story. And maybe the clearest sign came from the White House response itself. Notice what nobody argued. Nobody claimed the 41 names had already been released. Nobody explained why compliance kept stalling. Nobody disputed that the court order came first. Nobody denied the administration desperately wanted those documents contained. The fight centered almost entirely on characterization. Direction versus guidance. Suppression versus deliberation. Interference versus communication. That is what legal and political systems look like when the factual battlefield becomes too dangerous to challenge directly. The argument retreats into language because the timeline itself already looks bad, and timelines are stubborn things. They do not care about party loyalty, cable news spin, or carefully worded statements drafted by communications advisors at midnight. April 19th. Court order already active. Bondi testimony Saturday morning. White House contradiction less than an hour later. Emergency Senate hearing Monday. Those facts stack on top of each other with crushing weight. So now the country waits for a federal judge to decide whether the words spoken in his courtroom carry real consequences or merely become another moment swallowed by partisan exhaustion. That is the real stress test here, not whether Donald Trump survives politically. He has survived scandals before. The deeper question is whether Americans still believe institutions can impose limits on powerful people once those people decide the rules are inconvenient. Because if court orders only matter when politicians voluntarily cooperate, then they are no longer truly orders. They become suggestions wrapped in legal formatting. And if that line disappears, what exactly remains between constitutional government and raw political force? That question is bigger than Pam Bondi, bigger than Donald Trump, bigger than the Epstein files themselves. If you made it this far, hit like because this story is moving fast. Drop your thoughts in the comments, especially whether you think Judge Sullivan will treat Bondi's testimony as operative fact or strike it from the record entirely. Share this with somebody following the Epstein case closely, and subscribe because Monday morning may decide whether this remains another Washington scandal or becomes something far more historic.